So yes. I'd also, in terms of the McMinn case, I think it's been relied on a good deal. The main aspect of McMinn and all the predecessor cases are zoning cases. And the question is, what could the legislature do, or the local legislatures is really what's involved in those cases. How can it restrict the use of somebody's house and for the purposes? Now, there's an earlier Supreme Court case which had said, well, you can zone in order to provide for single-family housing and the like, and some of the earlier cases before McMinn, which I think seemed to be statutorily based by this court, said, well, you have to have some alternative. It can't be just talking about family. And at McMinn, the conclusion was that the definition there, where the usage would be, was absurd. But also, it's a criminal law that's involved.
Suppose we disagree with you and say that there is a right to marriage. What follows from that? What would the consequences be?
Well, I mean, it depends on what you say. I mean, we certainly hope you don't do that, but if you say, you know, well, I'm sorry.
That the other side said there were no consequences in Massachusetts, and you would expect the same thing here. Would you agree with that?
I have no way of really speculating whether, in terms of the consequences of whether there would be riots or the like, if that's what he was talking about, or, I mean...
I'm not speaking of violence in any matter. I just want to know, what would the practical consequences be in terms of anything, economics or...
Well, I assume that if you say that, then at least the benefits and the burdens that exist with respect to married couples now would also apply to the same-sex married couples.
You can't identify any adverse consequence, Mr. Schiff, can you?
No, I don't, but
in fact, your client's position is that it might be a good idea, but the legislature should do it, correct?
Well, we certainly have no objection to the legislature.
But could a let me change the question slightly. Could a legislature believe, whether your client is saying it or not, or whether you're saying it or not, could a rational legislature conclude that changing the traditional definition of marriage would have harmful long-term effects on the family?
Some of the arguments are made in the amicus briefs, what you're saying is other people can make those arguments, but you don't want to. Well, the legislature, I mean, under rational basis, the legislature, the idea, the legislature can make choices. I don't think it's black and white, but we aren't making that argument, and we wouldn't know exactly. I don't think the studies have been such, but we're not making that argument.
They can't make choices on moral or religious grounds.
Absolutely not. On the question of the claim for gender discrimination, I guess I'm in the same position.
Actually, let me take you back to the answer you just gave to Judge Separkis. I understand there are cases that say they can't make choices on moral or religious grounds. Was Brown against Board of Education not a morally based decision? I mean, does morals have nothing to do with this?
Well, I guess... Well, Brown, of course, I mean... We were dealing there with the 14th Amendment
But isn't there a moral principle underlying the 14th Amendment? A principle of equality that is a moral principle that we all respond to.
Well, okay, I guess one can say, I think Romer was basically saying that you can't discriminate because a particular group is simply morally objectionable, which I think is different from Brown Board of Education, which, after all, undid, I don't know, Plessy against Ferguson, about 50 years of probably a bad decision and morally objectionable when it was issued. But I mean, so maybe my statement is too broad, but I think basically I'm still agreeing with Judge Steparik that the state can't act simply because it doesn't like gays and lesbians. So it's. But I was going to say, if on gender discrimination, I'm with Ms. Kerner. I have never been able to understand the argument as to why this would be gender discrimination. And we talk about it in our brief, and I guess I will leave it at that. But I am puzzled. And of course, in this case, the main argument has been that there has been gays and lesbians have been discriminated against for years because of their sexual orientation. And if there is any discrimination, unjust discrimination, I think it's based on sexual orientation and not on gender discrimination. And it totally puzzles me. The answer to one of your questions, Judge Kaye, according to the Census 2000 special report, which I think we cited in our brief, in New York, households comprised of same-sex unmarried partners represent 1.3% of all coupled households. To the extent there's a claim that there is under-inclusiveness, the fact is that while there are a substantial number of same-sex couples, it's still a very small percentage of under-inclusiveness. Now, the courts have said, at least the Supreme Court has said, that one should act, that in terms of discrimination, or if the court can act in an incremental fashion, you don't have to deal with everything at one time. Now, this is a peculiar situation. I mean, this statute was, domestic relations law is more or less 100 years old, and I don't think anybody 100 years ago was thinking about this issue. It just wasn't on the radar screen. Of course, there wasn't any radar then either. And indeed, a good part of the argument that we've heard today and in the briefs has been, well, the same-sex couples have families. Now, this is also a fairly recent phenomenon. I think one of the briefs, Mika's briefs on their side, says really something that's become prevalent perhaps in the last 10 years. So it's certainly the kind of thing that the legislature is one that can deal with this on an incremental basis. And I don't think because there's something relatively new that all of a sudden this law becomes unconstitutional. So I think Mr. Kerner covered most of these arguments, and I would just ask that you affirm the decision below.
Thank you, Mr. Schiff. We'll save the time you have left over for your next appearance here. Mr. Jordan.
Afternoon, Your Honors.
Good
Chief Judge,
afternoon.
my name is Patrick Jordan. I'm here with Jeffrey Jameson, both our Assistant Corporation Counsels for Albany, here for Respondent John Marsley, City Clerk of Albany. The first point in our brief is simply the fact that the City Clerk does not have the ability to do what the petitioners are asking him to do. He has to follow the domestic relations law as it is written, as it is factually and particularly read, and as the Department of Health has specifically instructed him to do. In addressing one of Mr. Kinlan's points, I hadn't, him saying that it is, can be read as he, can be read as she, and bride can be read as groom. That's the first time I've heard that. And the respondent's reading of the DRL, it never says simply he or she. It says he and she, bride and groom, man and wife. They're very specific. The statute needs to be read as a whole, and that this particular section of the statute applies only to man and wife. That is who the state says can marry. I'm not sure that I want to belabor co-counsel's points. In looking at the Onofre case and under 21, all of your honors have brought those cases to light. They do deal in a certain way with sexual orientation, and this court has dealt with sexual orientation as looking at it through a rational basis test.
Well, your adversary says that even, Ms. Kaplan says that even looking at it through a rational basis test, it fails.
Your Honor, I would respectfully disagree with that. Looking at Onofre and, well, Onofre in particular, dealing with a state consensual sodomy statute, one that dealt with married couples different than unmarried couples. Those are two very distinct groups. Why were they singled out by the legislature? I don't know. It also dealt with what could be a potential harm, as in Lawrence, Texas. Texas statute was aimed at the possibility that homosexual sodomy or consensual sodomy would somehow endanger the other person. How can you say that it could not endanger a married couple in the same fashion? Therefore, it fails the rational basis test. The state legislature, when looking at the domestic relations law, does not have to voice what its rational basis was. The court can infer what that could be. The co-counsel has stated several times that, and so hasn't the petition, that the state's most likely aim is at procreation. And as several of your honors have pointed out, the most natural form of procreation that has been brought through the traditions of this country and the state is between man and woman. Judge Graffio did point out that insemination is a viable alternative now. However, the overwhelming majority of couples in this state and country rely on natural pregnancy. I would like to point out, we've discussed this amongst each other, that in looking at several of the cases that the petitioners are relying on, particularly many of the fundamental cases dealing with racism, if you read the cases that have dealt particularly in that area, it seems that the state legislatures there were aiming particularly at that group. That was the goal of the statute. Therefore, it's struck down as invidious discrimination. The state, in creating the domestic relations law, looked at, as we've already discussed, the traditional union of man and woman. The fact that same-sex couples at a later point were deemed not to fit into the domestic relations law was not the goal of this legislation. And therefore,
It has that effect. It may not have been the goal, but it has that effect.
correct, Your Honor. But in looking at a rational basis, all of the effects do not have to point you in one direction. The state legislature has a rational basis for why the law has not been changed. And as both sides have pointed out, the state legislature is looking into different ways to improve how this group is looked upon by the state. I know the City of Albany and the City of New York have both taken aim at that. The legislature, it doesn't sit year-round. They don't work in overarching goals. It has to be taken step by step. They are, it appears, taking incremental steps. There's no reason why